Everyone, welcome to our 2022 Elder Law Day Summer Series. My name is Christy McKenzie. I am the Assistant Coordinator of Neighborhood Services here in the Department of Senior Services with Erie County. I would like to take a minute to thank those who have helped make this series possible again this summer, including our County Executive Mark Polenkars, Karen Nicholson, the CEO for the Center for Elder Law and Justice, and our own Senior Services Commissioner, Angela Marinucci. We will be recording this program and it will be available shortly on our website where you registered at erie.gov/ELD. We'll also be asking that if you have any questions, you type them in the chat and we'll be answering them throughout the presentation. Please refrain from including any personal information in those questions. Allow me to introduce our guest speakers today. Jamie Smith. Jamie is a partner at Smith Vavonese. She concentrates her practice in the areas of estate and trust planning, elder law, and estate administration. Jamie also serves on the board of directors for the Center for Elder Law and Justice and is a member of the Estates Analyst of Western New York. And Rob Neal is a staff attorney at the Center for Elder Law and Justice in the Healthcare Advocacy Unit. Rob represents clients in appeals and grievances involving Medicaid, Medicaid managed long-term care, Medicare, and private health insurance companies. Welcome, and I'll turn this over to you, Rob.
All right, thank you, Christine. Can you hear me okay? All right, great. Okay. So thanks everybody for joining today. As Christine said, my name is Rob Neal. I'm a staff attorney with Center for Elder Law and Justice, located in Buffalo, New York. As a brief intro, Center for Elder Law and Justice is a legal services nonprofit. We provide services in a number of areas: housing, income maintenance, immigration. I do healthcare work. As Christine said, I do Medicaid, Medicare, and private insurance. Today's presentation will be focused on Medicaid programs, Mltc, and common issues that I see and regularly with Medicaid and Medicaid managed long-term care, as well as institutionalized care. And Jamie's going to talk about the financial and eligibility aspects of the Medicaid program after me. So, generally speaking, what is Medicaid? Medicaid is a state-run insurance program. It is dual funded, both federal and state. And it is for generally speaking, for low-income individuals. Easy way to remember the distinction between Medicare and Medicaid, because there's often confusion between those two. Medicare, we care for the elderly. Medicaid, we aid the low income. Medicaid is, so who is eligible for Medicaid? Pretty much everybody in New York State is eligible. There's no age restrictions. The only restrictions are based on financial eligibility. There are two main eligibility categories within Medicaid. One being what's called Magi. Magi stands for Modified Adjusted Gross Income. So Magi eligibility category serves people that are 19 to 64 and not Medicare eligible, children aged 1 to 18, infants under the age of 1, pregnant individuals, and parents and relatives and caretaker relatives of any age. With the Magi category, there is an income test, but no asset-based test. That's the main difference between Magi and non-Magi categories. The non-Magi category covers, is popularly described as aged, blind, and disabled. That means people that are over the age of 65, blind, or have a disability are covered. This has both an income and an asset test. I'll discuss the income and asset test very briefly, but Jamie really is going to touch on that mostly. So, what does Medicaid cover generally speaking? Like most insurances, Medicaid covers regular examinations, immunizations, doctors and clinic visits, medical supplies and equipment, lab tests, x-rays, vision and dental, skilled nursing facility care, hospital stays, emergencies, and drugs. The really important part about Medicaid, at least for our purposes, for mine and Jamie's purposes, because we deal mostly with, well, I mean, I'll take any Medicaid case, but so much of Medicaid work involves long-term care, planning for long-term care needs, and aging in general. And Medicaid really is the only provider of long-term care insurance in the state and in the country generally. Medicare does not really provide any long-term care services. It does provide some hospice care and limited like post-acute care in facilities, but for the most part, Medicaid is really the only provider for long-term care. Private insurance also does cover it on occasion, but those plans are really being phased out, and folks who have them, they're really only available on pretty Cadillac plans. You kind of pay a lot out of pocket for these. So often they don't pay, and many people who have long-term care needs towards end of life or even early in life, although that's less common, end up relying on Medicaid to pay for those services. So I'm just going to briefly touch on resources and income, although Jamie will go into this. So these are the Magi limits for 2022. Like I said, Magi, the disabled, aged, and blind category, has both a resource and an income test. Currently, for single individuals, income or resources rather are limited to 16,800, and couples 24,600. Income is for single folks 934 or 1367 for a couple. Now there's actually a $20 disregard, so it's actually 954 and 1387. But the income and asset limits will also be changing in 2023, and I'll discuss that briefly too. So the Medicare Savings Program is one of the other great benefits of Medicaid. Beyond providing coverage for services itself, Medicaid rather, also can help pay for your Medicare premiums and co-insurance and co-pays and whatnot. So Medicare Savings Program, it's not exactly a misnomer, but it is funded by the state Medicaid program. So Medicare Savings Program is actually a New York State Medicaid program that allows eligible individuals to meet some or all of their cost-sharing obligations under Medicare. Currently, there are 3 categories: qualified Medicare beneficiary, sometimes called QIMBY, specified low-income Medicare beneficiaries, SLIMB, and qualified individual program, QI. Starting next year, they're going to be merging these. It's only going to be QIMBY and QI, but for all intents and purposes, it will cover the same things, which I'll discuss in a second. But again, just as the Medicaid asset and income limits are increasing, which are the eligibility categories for the MSP program itself, are going up. So Medicare Savings Program, QIMBY, which is the highest level, will help pay for Part A premiums for individuals without enough work history to get premium-free Part A, and it will pay Part B premiums, deductibles, co-insurance, and if you qualify for this program, you also cannot be charged Medicare co-pays. SLIMB and QIMBY again will be merged next year, but those eligibility for those programs will pay for individuals' Part B premiums. Just like with, and Jamie will get into this, just like with the Medicare program itself, you can divert excess income into a pooled trust in order to qualify for an MSP program, even without applying for full Medicaid benefits. If you don't receive Medicaid and divert your excess income into a pool trust, you likely qualify for an MSP. If you're not automatically screened, you should speak to your local Department of Social Services. So the local departments of social services are supposed to be screening every applicant for all for the most beneficial income and asset category that they apply for, or that they may be eligible for, and any programs such as MSP. So unfortunately, obviously, practically speaking, that doesn't always happen. So we should be mindful to ask caseworkers or whomever we may be working for at the LDSs for screening for certain programs like this. Okay, so this slide, and again, I'm just going to go over this briefly because this is the, Jamie will discuss this at length. In 2023, these are the changes to the income and asset tests for MSP and Medicaid, generally speaking. So they're going up quite a bit. For single individuals from 934 to 1563, for couples from 1367 to 2106. And the Quimby levels are the same as Medicaid. QI is slightly higher because it only pays, again, for the B premium, whereas Part A will pay, whereas Quimby, rather, will pay Part A premiums and a lot of other costs associated with Part B care. So before I move on, does anybody have any questions generally about the Medicaid program?
There aren't any questions in the chat yet, Rob.
Okay, great. All right. Again, I'm just going to go over this briefly because this is what Jamie will be discussing. But just because somebody doesn't initially on paper qualify for Medicaid, if somebody is over income or is over income for Medicaid, they can still spend down their money. There are a number of ways in which that can be done, whether it's providing medical bills to the DSS or diverting money, but I'll leave that to Jamie. Okay, so like I explained before, the importance of Medicaid as relates to long-term care planning and elder law really relates to its coverage of long-term care services. Medicaid, under Medicaid, you can get either long-term care in the community, which would be through the Medicaid Managed Long-Term Care Program, called Mltc. There's also institutionalized care in skilled nursing facilities. And both of those have different income and eligibility and asset requirements that I'll go over briefly. Again, Jamie will discuss those more at length. So Medicaid Managed Long-Term Care are insurance plans that are paid a monthly capitated rate by the New York Medicaid Program to approve and provide Medicaid home care and other long-term care services to people who need long-term care because of a lasting health condition or disability. Mltc plans decide how many hours you may receive and arrange for care by a network of providers, and they also manage and pay for other long-term care services. So what's important here is that if somebody, what Medicaid will pay for is, or in order to be eligible for managed long-term care, one needs to need assistance with both IADLs, which are incidental activities of daily living, such as paying bills, managing medications, things like that, and ADLs, activities of daily living. These are transferring from beds, ambulation, managing stairs, transportation, things like that. If one needs assistance with both IADLs and ADLs for more than 120 days a year, then they are eligible for managed long-term care. Managed long-term care plans are quite popular. And the reason being, as elder law attorneys and as long-term care planners, um, many people want to remain in the community, right? They want to age with dignity. They want to age with at least moderate independence, even if they need some assistance. That's why managed long-term care is such an important program. It allows people to remain in their homes and get the care that they need to keep them, one, to ensure that they are safe, but two, to keep them out of nursing facilities. Now, that isn't to bash nursing facilities, generally speaking, but most people, in my experience, and I can imagine, that you would agree, many people want to age in their home as long as possible. Within managed long-term care, the issues that I deal with most frequently are reductions in services, right? So let's say somebody qualifies for 30 hours a week of CDPASS aid. CDPASS is a program and it stands for Consumer Directed Personal Assistance Services. Again, that provides assistance with IADLs and ADLs in the home. So somebody is receiving 30 hours of assistance through the CDPASS program on occasion, and we see this somewhat regularly. Their MLTC plan may attempt to reduce them down to 15 hours or whatnot. We can go through the appeals process to assist ensuring that the reduction doesn't happen. Other cases we see are denials of increase requests. So let's say, again, the individual has 30 hours and really they need 60 hours. Folks can request that through their MLTC plan. Practically speaking, often they get denied, and we can appeal that and hopefully get a win there. And now what we're seeing, because about 2 months ago, how MLTC plans are assessed changed. We're now seeing more general eligibility denials for MLTC. I had never, I've been doing this, well, just for about 2 years now, but I'd never seen any denials for general MLTC programs, and now they're starting to flood in. The reason being, it used to be that the MLTC plan itself would do the assessment and then make their own decision as to approval or denial. Now it is that the MLTC plan will do the assessment, and it will go to what's called the conflict-free evaluation center, who now makes the determination based on the MLTC's assessment. So not everybody needs to enroll in an MLTC plan. Folks can do it on their own, but some people do need to enroll. So as of December 2014, any Medicaid recipient over the age of 21 who is eligible for both Medicaid and Medicare, called dually eligible, and requires more than 120 days of skilled nursing care, must enroll in an MLTC plan. So in order to enroll in an MLTC, you apply for Medicaid with your local DSS. If you're already on Medicaid, that part is taken care of. You'd contact your local New York Medicaid choice, the enrollment broker, to schedule a conflict-free assessment to determine your long-term care eligibility. The number's right there. When approved, the member has 75 days to choose a plan, or they will automatically be assigned one. And then you'll be assessed again for the MLTC plan you want to pursue in order to create your personalized care plan. Each of the MLTC plans, whether it's CDPASS, adult daycare, they all have slightly different eligibility requirements. So that's the end of that process. The specific MLTC plan that you want to choose. So that's community Medicaid. That's long-term care in the community. Institutionalized Medicaid is for folks who need assistance in skilled nursing facilities. While MLTC is capitated service, institutional Medicaid is under fee-for-service, which is in which the provider is paid for every Medicaid eligible service rendered to a beneficiary. Institutional Medicaid covers all costs associated with residence inside of a skilled nursing facility. That would be any therapies, drugs, as well as room and board. The difference in income and asset requirement that I alluded to earlier for institutionalized Medicaid is, in the community, one just needs to abide by the general Medicaid income requirements, right? At $954 in income a month, so long as you're at or below that, or if you pay a spend down, you remain eligible. With institutionalized Medicaid, one is required to pay their NAMI, net adjusted monthly income, in order to stay in that institution. Now, what that means is the asset requirement essentially remains the same, but in institutionalized Medicare, even if you make well over or well under the Medicaid limit, you have to pay all but $50 of your income to the facility, and that's a NAMI payment. It's essentially it's essentially an insurance premium. So again, let's say that they are exactly at the Medicaid asset limit, $954. They would pay $904, and that $50 is kept as personal money for use for snacks, haircuts, what have you. I mean, anything you want. But and same thing, even if somebody has $3,000, which would be well over Medicaid asset limit or income limit, they would pay all of that $3,000 minus the 50, so $2,950. I hope my math is correct there. Some important changes to in Medicaid enrollment appeal and fair rights hearing. So when somebody gets a decision as to their Medicaid eligibility, or a reduction like I was talking about, or a denial even for an increase, an enrollee is entitled to written notice at least 10 days before the plan is allowed to reduce or stop any services. In order to get to, so the first step of getting to a fair hearing is there is an exhaustion requirement. So the enrollee must first request an internal plan appeal. So an enrollee will get a denial letter saying you've been reduced or you've been denied for XYZ program. It will give you a date by which you must request an internal plan appeal. If you do that, you will then receive first an initial adverse, well, if you get denied, you'll get an initial adverse determination. If you disagree with that again, you have to appeal again, under this internal plan appeal. So there's essentially 2 internal plan appeals. If you get denied again, you will receive a final adverse determination, and at that point, you can request a state fair hearing. The enrollee has 60 days to make this request after the final adverse decision is received. The enrollee must request an internal plan appeal orally via telephone, may request rather, but must follow up an oral request with a written request by mail or fax. Enrollee must give authorization to anyone requesting an appeal on their behalf, or the appeal may not be processed. Oops. Okay. Aid continuing must be requested twice during the appeals process. You must request, so aid continuing, before I go on there, is in the instance that somebody's reduced, right, from 30 to 15 hours, enrollees have the ability to request aid continuing, which would make sure that during the process of the appeal, their actual hours or services are not reduced. So by requesting aid, if you want to keep the hours at 30 rather than 15 during this appeals process, you have to request aid continuing. Enrollees have approximately 10 days to request aid continuing at this stage. Once you receive a final adverse determination from the plan, you must again request the aid continuing from OTDA, the Office of Temporary and Disability Assistance, when you request the state fair hearing. This request must also occur within 10 days of the final adverse determination, even though you have 120 days to request a fair hearing. So people will do that. Sometimes they'll accidentally skip over the aid continuing part on the request for fair hearing. And if you miss it within that 10 days, even if you request the fair hearing timely, the plan can reduce you in the interim. Enrollees have 120 days to request a state fair hearing from the date of the final adverse determination. Only exception if the plan fails to timely respond to an internal plan appeal. enrollee may request a state fair hearing without receiving a final adverse determination from the plan. Additionally, there are pretty specific notice requirements on the agency. If they don't mail it properly or within a certain time frame, this can be told as well. Major issues that we're seeing in Western New York, especially during COVID, is transitioning from a rehab or skilled nursing facility back to the community. Budgeting is always one. Environmental modifications, staffing issues this is more in rural areas than in the cities, but it is happening generally. A lot of these agencies are not able to fully staff people's authorized hours. That's been a major concern, and unfortunately, there isn't a great solution as of yet, other than some workarounds. There's issues in suburbs with limited access to transportation, and again, really the issue that I see most, that I deal with most, is reductions in 8 hours and/or denials of increase. That's the vast majority of my Medicaid cases, and then I would say the other big chunk is budgeting. Okay, so I want to make sure Jamie has her time, so I'll open it up to any questions briefly while Jamie prepares, unless she's ready to go, and then we can just do some at the end.
We had a question. I think they're just double checking something you may have said. If you have excess income deposited into a pooled trust, then can you apply for the Medicare Savings Program?
Yes. So generally speaking, with regard to the Medicaid Savings Program, and Jamie, maybe it's more appropriate that you speak to this in detail, but what we would do is we would have them apply to Medicaid, get a denial, which is how you get into the pool trust in general, which tells you what the spend down is, and that's what gets diverted into the pool trust, and by that you can become eligible for both Medicaid and the Medicare Savings Program.
Okay, I think that's it for right this second.
Okay. Ready, Jamie?
I am. You're gonna do my slides, right, Rob? Okay. Okay. Good morning, everyone. So I'm going to talk to you specifically about community Medicaid waiver programs and pooled supplemental needs trusts. So as an elder law attorney, when I meet with clients for the first time, their major concern is, how do I pay for long-term care? No one wants to go into a nursing home, and if I had $1 for every time a client told me they weren't going to go in, I'd probably be retired by now. But certainly as we age, the likelihood of us needing more care increases. So there's really 3 ways that we pay for long-term care, and Rob alluded to some of these. So long-term care insurance, that's private insurance that you pay for. The problem with long-term care insurance is that it can be expensive. I have clients who come in at retirement age who are, relatively healthy, 60 to 65-year-olds. And when they price out long-term care insurance to get a policy that's going to cover what it would cost to be in a nursing home today, which on average is about $15,000 in Western New York, the premiums for that policy are about $5,000 to $7,000 a year. That's per person. And that is a premium that somebody pays indefinitely until they either go on claim or they pass away. The other issue that I see with long-term care insurance is that clients who purchased it 10, 15 years ago are now receiving these premium increases, saying if you want to keep the same coverage that you originally had 10 years ago, your premium is going to go up, and in some cases it doubles. So that can be very pricey for people. And the long-term care insurance companies are very picky about who they'll insure. You have to medically qualify in order to be covered. And a lot of people who are in their 60s who may have, had a knee replacement or may need a knee replacement or hip replacement are being denied. The other issue I see with long-term care insurance is that you know, somebody might have a policy that pays $250 a day for a nursing home when it actually costs $550 a day. So they may have coverage, but that coverage may not be sufficient. And they might end up using their, you know, assets and income to help pay for their care, which they had purchased this policy to avoid doing that in the first place. The second way to pay for long-term care is obviously private pay. That's when a client uses their own assets and income. And again, in Western New York, the average cost of a nursing home is about $15,000 a month. If somebody is living at home and they need 24-hour care, that could be even higher. Most agencies will charge $25 to $35 an hour. And when you do the math, you know, you could be over $18,000, $20,000. So the final way to pay for long-term care is Medicaid. And that's kind of what my clients are interested in hearing about, because if they don't have long-term care insurance, they don't, you know, they're not self-insured, they're not millionaires and billionaires where they could just, you know, use their income to privately pay indefinitely. The question becomes, how do I apply for Medicaid? How can I qualify for Medicaid? And what I tell them is you have to be at or below certain resource and income allowances to qualify. And if you're not, let me show you how you can be. Next slide, Rob. Okay, so as Rob mentioned, most people are concerned with remaining at home. No one wants to go into a nursing home for good reasons, obviously. So we do have these waiver programs where the state applies for a waiver from the federal government to provide skilled levels of care, but in the community. And the two main waiver programs that my clients utilize are the Managed Long-Term Care Program, which Rob talked about. This program is most appropriate, in my experience, for people who need help with task-oriented assistance. So dressing, bathing, transferring, etc. Some of my clients get therapy under this. They also get daycare. So this is kind of a program for people who are cognitively okay, but need those assistance or need that assistance with activities of daily living. The second waiver is the nursing home transition and diversion waiver. This waiver is meant to transition people who are in nursing homes back into the community and divert people from going in the first place. This waiver program really helps people who have cognitive issues, whether it's dementia or Alzheimer's or just, you know, a lack of safety awareness. Under this program, my clients are able to get more hours than they would under the Managed Long-Term Care Program. Next slide, please. Okay, so why consider a community Medicaid program? Well, obviously, you're going to be able to stay in your home or your apartment, and you can receive that home care or that care that you need without, you know, having to go into a facility, whether it's assisted living or skilled. You can also preserve assets and income and not use your own funds to privately pay. The reality, however, with community Medicaid and the waiver programs is that it can take a long time before those programs are in place. You know, you have to first file an application to financially qualify for Medicaid. They're supposed to issue a decision within 45 days. That rarely happens. After that decision is issued, then if you're going for the nursing home transition and diversion waiver, you have to come up with a care plan that has to then get approved by the state. And sometimes there's revisions and it goes back and forth, etc. Or for the Mltc, you have to pick either an agency that you want to work with, or if you're going through the consumer directed program, you're allowed to pick your own, you know, people. You can hire, fire, schedule them, and Medicaid just does the payroll for you. So for somebody who needs a lot of care immediately, this can be a hurdle. Now, we do have an expedited process called immediate needs, where they're supposed to determine your eligibility within 2 weeks, and you're supposed to get care in place sooner. But in my experience, that doesn't really happen as quickly as, you know, what it says on the books. So that is an issue. Okay. So how do we qualify for these community Medicaid waiver programs? So if you're a married couple, The spouse, we normally call this person the community spouse because we're talking about somebody who's institutionalized and somebody who's not. But in this case, the community spouse is the well spouse, the spouse that doesn't need Medicaid. He or she is allowed to keep $74,820 in countable or non-exempt assets. So the exempt assets are the primary residence. That could be up to $955,000 in value, which is a pretty nice house in Western New York. But remember, this takes into account all of New York, including New York City. Retirement accounts of any value. Once you turn 72, you're required to start pulling money out of those retirement accounts. And by doing that, Medicaid exempts the entire corpus of that account from being considered available to pay for your care. Now, the distributions that you're required to take are budgeted as part of your income because Medicaid looks at assets and they look at income, but the principal of those retirement accounts are exempt for your spouse or your children, which is pretty big. Life insurance, if the face value is $1,500 or less, is also exempt, or if it's a term policy and has no cash value. One vehicle of any value, so you could technically have a Rolls Royce. And then any monies you put into a prepaid irrevocable burial account are also exempt. So what I tell my clients is we're all going to die and there's a cost associated with that. So if you know you want to have a traditional burial or you want a cremation and you put money into an account with a funeral director, it goes into an interest-bearing escrow account. They don't put it into their operating account, and it's set aside, earns interest for your burial. And you can really prepay for everything except for like a funeral, lunch, or brunch. And I forgot to mention that the spouse who is applying for Medicaid is also allowed to keep $16,800 in non-exempt assets. So the non-exempt assets would be, you know, if you had a summer home or cottage, it would be, you know, any investments or cash in the bank, etc., above those allowances. So for a single individual, it's pretty much the same, except for there's not a community spouse resource allowance, but that individual living at home can keep $16,800. Typically that's in the bank, but it could be stocks, it could be bonds, etc. The house is also exempt if the person is residing there. Retirement accounts are exempt, the life insurance, one vehicle, and the burial account. Next slide, please. Okay, the income is a little bit tricky. And this really depends for married couples. There's two methodologies that the Department of Social Services uses to budget the income for a married couple. And basically, whichever methodology is more advantageous to that couple, that's the budgeting that DSS has to use. So if the well spouse's income is over $3,435, then the county says, okay, you can keep all of your income. And income is Social Security, pensions, IRA distributions, etc. Anything you pay tax on basically is income. So if that well spouse's income is already over $3,435, they get to keep all the income. Their income is not counted in determining the Medicaid applicant's eligibility. And the Medicaid applicant spouse can keep $934 a month with that $20 disregard that Rob mentioned. So if I have a spouse, a married couple, and the spouse has $6,000 a month in income, and the other spouse has $2,000, the moneyed spouse with the $6,000, that's protected. They can keep that. If, however, the well spouse's income is below $3,435, then the Medicaid applicant is allowed to contribute some of his or her income to that well spouse to bring them up to that $3,435 level. In that scenario, that Medicaid applicant spouse can only keep $433. And then the county does also allow from the income an additional allowance for health insurance premiums. So if you pay, $65 a month to Univera, Independent Health, they will give you an allowance for that as well, because it's cost effective for them if you keep your private health insurance. Medicaid always wants to be the payer of last resort, so they want that independent health, et cetera, to pay first. For single individuals, as Rob mentioned before, the person can only keep the $934 a month with the $20 disregard. They will also, again, give an additional allowance for health insurance premiums. And any income that's over that, $954, you're still considered eligible for Medicaid, even though your income is above those levels, but you have what's called a spend down or excess income. And as Rob mentioned, that spend down amount either has to be paid to the managed long-term care agency that you're working with, or directly to the Department of Social Services, and then Medicaid pays, the remaining bills that you have, medical bills. Or you can show the county, you can submit bills every month saying, hey, I've incurred medical bills that meet or exceed my spend down, and then Medicaid gets activated, which is a pain. Or the third option, which is the most popular, is to divert that excess income into a pooled supplemental needs trust, which by doing that, the county then pays 100% of your medical bills, and that income that you put into the trust can be used to pay for things that Medicaid doesn't pay for, like rent or, your utilities, et cetera. And we're going to get into that a little bit more in a minute. Next slide, please. Okay. So people come into me and say, okay, that all sounds great. I want to stay in my home. I understand what the income and resource limitations are. How do I financially qualify for this program? And what I tell people is, most people are aware that there is a 5-year look back for nursing home Medicaid. We don't have a 5-year look back, though, for these community Medicaid waiver programs. Technically, as of October 1st of 2020, a 30-month look back was supposed to be instituted for some of these Medicaid waiver programs, and I'm not really sure how they decided, we're going to impose it for the managed long-term care, but not for the, nursing home transition and diversion waiver. But that's what the governor's Medicaid redesign team decided. But that 30-month look back has not been implemented. And we don't know if it will ever be implemented. I was at a conference a couple of weeks ago, and the director of the New York State Department of Health Enrollment and Eligibility Division for Medicaid was there. And she basically said, if it does get implemented, New York State's going to have to first obtain a waiver from Center for Medicare and Medicaid Services. And assuming they did do that, it's probably not going to be implemented until 2024. So that gives clients still planning opportunities to divest themselves of assets so that they can qualify for these community Medicaid waiver programs. Next slide, please. Okay, so the ways that we can financially qualify for community Medicaid. Well, first, we can spend down on excess resources. So do we want to purchase a new vehicle? We know that that's an exempt asset. Is there anything we want for our home? Furniture, carpets? Do we need to put a new roof on the house, or a furnace, or, a granite countertop, or, change the bathroom? Do we want to prepay for our funerals? So we look at doing that first. And then we say, okay, if we don't want to do that, or we've done all we want to do, you can actually make a gift of the assets that put you over the applicable thresholds to qualify to your children or other family members. Or you can put them into what we call a Medicaid Asset Protection Trust. And we're going to delve into that deeper in a minute. Next slide, please. Okay, so by transferring assets out of our name, technically, if we were to apply for these community Medicaid waivers the next month, we would be financially eligible. And right now, because there's no look back, there'd be no sanction imposed against you for doing that. So outright gifts, that's kind of self-explanatory. You can obviously give property or money or, assets to family members or whomever you want to benefit. It's cost effective. But the disadvantage is, once you give away money to your children, it's their money. So if they wanted to, they could spend it however they desired. You know, if they are sued, their creditors could get at that money if it's in their name. Or if they pass away, it could go to their estate and to, you know, their spouse or children or to their creditors. And that may not be the way you would want those assets to be distributed at your death. And sometimes outright gifts can lead to adverse capital gains tax consequences. So if I just transfer the deed to my property to my children and I paid $100,000 for my property and now it's worth $250,000, they take subject to my cost basis. So when they go to sell it, they're going to pay capital gains tax on that difference between what I paid and what it's worth when they sell it. So as an alternative, next slide, please. People also can use what's called a Medicaid Asset Protection Trust. And the advantages of this, when the person passes away, the assets that are in the trust go directly to the beneficiary, so it avoids probate. It starts the 5-year clock ticking in case anyone needs skilled nursing home care. And certainly it makes the individual eligible the following month currently for community Medicaid. The trust protects the assets from the children's creditors. Believe it or not, the client setting up the trust has the right to change who the beneficiaries are, so it's not set in stone. They can also change who the trustees are. They can provide that the trust pay money to their kids or grandchildren or whomever during their lifetime if they wanted to be able to do that. And then at their death, the children receive, or the beneficiaries receive, what's called a stepped up basis on most assets that are in the trust. So the example with the real property, if it's worth $250,000 at my death and my children receive it from my trust, their basis is $250,000. It gets stepped up to whatever it was at the time of my death. And that's true for stocks and mutual funds, really anything except for non-qualified annuities and savings bonds. These trusts are also structured so that any income earned on those assets during the grantor's lifetime gets paid by the grantor, claimed by them on their tax return. The disadvantage of setting up this type of trust is obviously you're going to pay an attorney to do it, so it's more costly than just giving money away to your kids. And it is more complicated to implement than just, you know, giving away assets. Next slide, please. Okay, so when a client decides they want to move forward with setting up this type of trust, you know, figuring out how much money should go into the trust, you know, really depends on what the client's goal is. If the goal is to qualify immediately for community Medicaid because someone needs assistance at home, then I would say all assets over those allowances that we talked about, whether they're married or a single individual, would go into that trust. And really, almost all types of assets can go into the trust except for IRAs, which are already protected anyway as exempt assets for Medicaid. So next slide, please. People are always concerned about whether they can make changes to the trust because this Medicaid Asset Protection Trust is an irrevocable trust. And I always explain to them that the answer is yes. The trust, the grantor rather, retains what's called a limited power of appointment. So again, they can change the beneficiaries, they can change the trustees. And then under our New York Estates Powers and Trust Law, there is a provision under 7-1.9 that says if an irrevocable trust, if you can get all of the interested parties to agree or consent, the trust can be amended or revoked. So the interested parties are the grantors and the beneficiaries. So if we can get all of them to sign off on it, then the trust can be revoked. And this is important sometimes because we'll set up these trusts for clients who are looking to get these community Medicaid services in place, but then something happens where they might need skilled care before we're through that 5-year look back, and then we have to go to Plan B, which is crisis planning, and that's beyond the scope of what we're going to talk about today. Next slide, please. Okay, so now I want to switch gears and talk to you about pooled supplemental needs trusts. And Rob will go to the next slide. Okay. So unlike the Medicaid Asset Protection Trust that I just told you about, a pooled supplemental needs trust is really a trust that's for a disabled person. So a Medicaid Asset Protection Trust, if a client comes in to see me, they're 60 or 90 or whatever, it doesn't matter if they're disabled or not, they can establish that trust. But for a pooled supplemental needs trust, the person has to be disabled, either receiving SSI, Social Security, disability, and if they're not, then a disability determination has to be made by the Department of Health that this person is disabled. But this is a tool that people use to keep additional income that they would otherwise have to spend down for Medicaid purposes or even assets. And the trust can be used to supplement what their government benefits don't pay for, what Medicaid isn't paying for. Pooled trusts are unique in that you have multiple beneficiaries. So they pool their money together for investment purposes, but they each have their own separate sub-trust account within the master trust. Next slide, please. Okay, so in order to qualify for a pooled trust, as I mentioned, you have to be disabled. If the person is over 65, again, that disability determination is required if they weren't receiving disability or SSI prior to the age of 65. And there is paperwork that the Department of Health and Medicaid has the doctor fill out, the primary care physician, and then that's given to the local Medicaid office who sends it to the Department of Health in Albany for that disability determination. A lot of the population that I deal with, they were not disabled prior to age 65, but because of their age, or if they have Parkinson's now or Alzheimer's, et cetera, they are now disabled and we have to go through this disability determination with the Department of Health. Next slide, please. Okay, so why would we want to have a pooled trust? Well, again, if we have assets above the 16.8 and we don't want to do a Medicaid Asset Protection Trust, or I would say the majority of my clients are more interested in the pooled trust for the income so that they don't have to pay over any of their income towards their, medical expenses. They can divert that excess income into the trust. It also helps people stay at home. If I have to live on $954 a month, I'm not going to be living very well, right? So the trust can pay for things like my utilities or my phone bill, or it can pay for my taxes on my house, etc. And it really helps people maintain a better quality of life in the community. Next slide, please. Okay, so the first party pooled supplemental needs trust would be a trust that's established by the disabled individual, himself or herself, and they would put their own assets or income into the trust. Now, you can set up a pooled trust whether you're under 65 or over 65, but the main difference is when you're under 65, if you, there will be no transfer penalties if you're receiving SSI. So SSI is supplemental security income, and you have to be disabled. You have to have, below $2,000 as a single individual to qualify for that benefit, or $3,000 as a married couple. And that benefit is really intended to pay for food and shelter expenses. So if I set up a trust when I'm under 65 because I received an inheritance from somebody or a settlement, etc., I'm not going to be sanctioned. I'm not going to be kicked off of SSI. So if this 30-month look back does get implemented, it's really kind of unknown at this time whether, the pooled trust is really going to be able to be used at all, and whether there's going to be a transfer penalty for people diverting income or assets into it. If I'm over 65, my only option for a supplemental needs trust is really this pooled supplemental needs trust. And there are sanctions if I later need Medicaid for having put assets or income into that trust. So you have to be careful as to what you're putting in there. To the extent you can show that the money that you put in came back to you or paid for things on your behalf, then the sanction will be reduced. And the pooled trust ends when the disabled beneficiary passes away. No disbursements can be made from the trust after that time, and any monies that remain in that trust at the death of the disabled person are gonna stay there. It's not gonna be paid to the beneficiary's family or friends, etc., like it would with the Medicaid Asset Protection Trust. But again, most of my clients are utilizing this trust for income, and everything that goes in every month is coming back out to pay for expenses. So there's certainly no requirement that any money remain in that trust at the time of the beneficiary's passing. Next slide, please. Okay, so as I mentioned, most people use this trust for their spend down, any income above the 954. But if somebody receives a direct inheritance and they're disabled and their parent or relative didn't provide for a supplemental needs trust under their will, this person can set up this trust to put their inheritance in to protect those monies. Some people who receive retroactive Social Security disability awards set up the pooled trust, or personal injury settlements, structured settlements, and sometimes excess resources. So it just depends on the client's needs. Next slide, please. Okay, so first party is set up by the disabled person. Their income or assets are used to fund the trust. A third party pooled supplemental needs trust is established by a third party, like a person's parent or friend or other family member. And that third party puts their money into the trust, not the disabled beneficiary's money. So if I want to leave money to my nephew and he's disabled and I don't want to kick him off of his Medicaid benefits, I could set up a third party trust, and my will could, say X percentage goes there, or I could put money in now during his lifetime, etc. With this type of trust, the main difference is when that disabled beneficiary passes away, 15% of what's in there is going to stay in the trust, but the other 85% can go where I designate it to go, to my other family members or whomever. Next slide, please. Okay, so what can the pooled trust pay for? It really depends on whether somebody's receiving supplemental security income or not. So if you're on Medicaid only, or Medicaid and some other benefits, but it's not SSI, generally the trust can be used to pay for any of your, expenses: rent, mortgage, condo maintenance, insurance, repairs, taxes, utilities, phone bills, furniture, pre-need, burial arrangements. Really the sky's the limit. The only rule is the trust will not give you cash, because obviously that would put you over the income limits, and it won't pay for gifts for third parties, etc. It has to be primarily for the disabled person's benefit, the disbursements. Next slide, please. So because SSI is intended to pay for food and shelter, the pooled trust really can't pay for those things for an SSI recipient, because that would kick them off of, or reduce, I should say, their SSI benefit. So for people who are receiving supplemental security income, the trust can be used, however, to pay for vacations or furniture, transportations, computers, education, and non-food and shelter expenses like telephone, cable, internet, etc. Next slide, please. So when somebody enrolls in the pooled trust and they want to start asking the trust to pay for things, the purchases have to receive prior approval. A beneficiary can't purchase something and say, hey, I want you to reimburse me, etc. There's a disbursement request form that gets signed and emailed to the trust. And sometimes the trustees will ask for supporting documentation, like an estimate on the cost of, the TV or furniture, etc. The pooled trust can also be used to pay for home care. So if somebody is receiving Medicaid and they're on one of the waiver programs, but they're not getting sufficient hours, their excess income or those resources that they have in the pooled trust can be used to pay for additional care, but they must be licensed agencies, providers, etc. Next slide, please. As I kind of mentioned earlier, the trust will not pay cash to the beneficiaries. It won't pay for capital improvements to property that the beneficiary doesn't own. It won't pay both rent and mortgage and property taxes. It won't pay for alcohol, firearms, illegal activity, and it won't purchase a car for somebody who it's not owned by the beneficiary. Next slide. Okay, so in order to qualify for the pooled trust, you have to be really in receipt of Medicaid, so you need an approval letter. You need that disability paperwork if you're over 65 and never were in receipt of Social Security Disability or SSI. And then there's an application that gets completed, and there's a joinder agreement. And that gets submitted after it's reviewed by an attorney to the trustees. And they meet once a month and they approve applications, and then you get a welcome packet in the mail. And once that occurs, you can start depositing your excess income in, or your inheritance, your settlement, etc. There's a great website that you can find out more information about the pooled trust. It's listed here. I would encourage you to go on and check it out. And if anyone has questions about it, certainly they can contact me, or there's an attorney referral list on there. They can contact any of the attorneys on that referral list as well. Next slide. Okay, last thing I want to mention, I know we're over our time. Some clients get confused between the Medicaid Asset Protection Trust and the pooled trust. And so what I tell people is they really can work together. So if I have a client come in and they've set up a Medicaid Asset Protection Trust because they want to qualify financially for community Medicaid, and they have, assets in there, whether it's stocks or real property, etc. And then they go on community Medicaid and they have a spend down, then we set up a pooled trust for their income. So the Medicaid Asset Protection Trust is something that I typically use for resources. And then the pooled trust is something that can be used for their income, so that we're sheltering both the assets and income and having Medicaid pay for that care. And I think, Rob, that's my last slide, right? Okay, so I don't know if we had any questions, Christine. I forgot to ask while I was presenting, but if there are any questions.
There are quite a few. I'm not sure if I'm able to get to all of them.
Okay.
Some are very specific. First, spouse refusal is still a thing for budgeting. Mltc community spouse is over income, but applying spouse is under.
Yeah, so this is the, I don't, Rob, do you want to talk about it, or?
So are we just talking about spousal empowerment budgeting generally? Because if so, yeah, the answer I think is just yes.
Yeah, so before, which it's very odd, I don't understand this process, but when you apply for like one of the waiver programs, they're supposed to budget you using just the regular community Medicaid budgeting, not the spousal impoverishment budgeting, which gives you the higher income and resource allowances. We never have our clients sign a spousal refusal. In my experience, and just to explain what that is, if a spouse has assets or income above the levels, they can also sign what's called a spousal refusal, saying, I'm not going to pay any of my income or assets towards my spouse's care. And then Medicaid has to determine whether the spouse's assets and income that is applying, just look at their assets and income. The problem with signing a spousal refusal, at least in Erie County, is you then get sued in family court by the county. And we were seeing that happen, and we were telling people, don't sign a spousal refusal, because they have to rebudget you using the spousal impoverishment budgeting, once you're enrolled. So it doesn't make sense, because then we have to try to explain to the county attorney and everything why you're really not a refusing spouse, because you're entitled to these higher exemptions. That's my experience, at least.
Yeah. So just to clarify for folks who may not be aware of what spousal impoverishment is, certain programs, including institutionalized Medicaid, allow for what's called the community spouse to keep more than would normally be allowed to under Medicaid budgeting. So let's say a husband is in a nursing facility, Normally they would have to pay all of their income as a NAMI. If they have a spouse that remains in the community, they can keep up. And Jamie, I forget the numbers exactly, but it's like 3,000.
3,435.
Um, the community spouse can keep up to that amount of income per month.
We have a couple more questions. Again, I'm not sure if we'll get to all of them. They're pretty specific. Someone that has $1,800 in SSI monthly also has $800 bills for cancer treatment. She's currently paying private pay in a dementia unit and has about $50,000 left in her account. Should she gift the money and apply for Medicaid, or should she do a pooled trust before she applies for Medicaid?
I'm sorry, can you repeat that again? I got lost.
It's in the chat, Jamie, if you
Oh,
want to take a look, because I had a little trouble following too. Looks like it was from, it's under Giuseppe, or Giuseppina, right? Is that the, yeah. So I have a consumer that has $1,800 in SSI monthly. She has $800 in bills for cancer treatment. She's currently private pay in a dementia unit. She has approximately 4 months left, $50K left in her account. Should she gift the money and apply for Medicaid?
When you say in a dementia unit, is she in assisted living or is she in a skilled facility? I guess that would be the question.
She may
Because
take something in the chat with that question and see if we can get more specific.
yeah.
We can move on to another one in the meantime. Is Western New York Pool Trust limited by geography?
It's not, no. You really can enroll, and this is not the only pool trust in New York. We have pool trusts downstate too. And the advantage is that you can really enroll in any pool trust. I think it's nice to have, if you're local, to have somebody to meet with if you want. Typically when a client, meets with somebody after they're accepted to the trust, they sit down and say, here are all my monthly bills. Here's what I want you to pay. They can talk to somebody directly, but certainly if somebody is, in Rochester and wants to enroll, they're able to do that as well, or New York City.
Okay, and then to clarify the first question, it's not a nursing home. And she said it's also not assisted living.
Yeah, I've only seen dementia units in skilled nursing facilities, so this is kind of confusing to me. I don't think in a nursing home it would make sense. In assisted living, I would say no, but
So there are assisted living facilities that have like locked units that are for people with dementia. And certainly nursing homes have dementia units as well. I guess it just depends on really where they are. I don't know what other facility they'd be in that would have, a dementia unit. But for assisted living, most of those facilities are private pay. There's some that have assisted living program beds, which are Medicaid beds. And if the person is in one of those facilities and were to transfer assets, there's no look back still yet for that Medicaid, but whether that facility has a Medicaid bed available is really what you'd have to look into. Most of these assisted living program beds, the facilities want private pay for 2 years. You have to go on a waiting list. So we really would need more detail in order to give you an accurate response.
Yeah, Medicaid will cover assisted living in very limited circumstances under a program called ALP, Assisted Living Program. And I don't remember the numbers specifically, but they limit the number of participants in the program throughout the state to a pretty small number, in the kind of low thousands, if I remember correctly. So they're pretty restrictive programs. Most assisted living is not paid for by Medicaid.
Great. I think a lot of these questions are pretty specific, like the first one I asked about the dementia unit. So maybe, because we're out of time and they're specific, if Jamie or Rob don't mind people contacting you, maybe by email or calling your office, if they have more specific questions, we can end the session now. If that sounds okay.
Yeah, if I'm assuming the PowerPoint will be distributed, and both mine and Jamie's contact information is on our slides.
The PowerPoint and the recording of this will be made available probably next week on erie.gov/ELD, same place everybody came to register. So with that said, I would like to thank Rob and Jamie for taking their time today and providing such comprehensive information to everyone. And again, I thank everyone for joining today as well. And please join us again for our final week of our virtual summer series next week on Tuesday and Wednesday at 10. We'll be including presentations on scams and estate and long-term planning. Thank you again.
Thanks, everybody.
Thank you.